So thank you all for joining me on this end of 2022, almost 2023. Been my absolute pleasure for those of you who are our clients to have the opportunity to serve you. For those of you who are professionals, the opportunity to work with you. I'm Emily Kile. So again, thank you all for joining us. For purposes of today's webinar, just assume I don't represent anybody. I'm not trying to give legal advice. As you all probably know, usually I need a lot more facts in order to give you answers to your questions, and we don't want to answer questions that are too personal since we're all on this together. Again, if you're just joining us, just go ahead and type in any questions you might have on the chat and the Q&A. I did get a couple of questions in advance, and so I'm going to start there. And if nobody asks questions, I'll just talk about the things that I know about, and hopefully that'll answer your questions. So first I have two questions from one individual, and the first question is, how often should I update my estate planning documents? And the answer is, it sort of depends. So if you have any changes that you need to make, like you've spent Thanksgiving with a relative who you nominated to be guardian for your kids, and it turns out they're not a very nice person, obviously you want to get those things updated as soon as you can. If you have named somebody to be your agent or your trustee and you're not in touch with them anymore, so changes like that, you absolutely want to, get those done as quickly as you can. We try to send out notification if there's been a significant law change that requires a change to at least enough people's plan that it makes sense to send that out as a general email, and then for you to make a decision as to whether or not that's something that impacts you. And I just recommend you pull out your binder or your documents once a year or once every other year, just generally, again, to go through it and make sure the plan you have works. If the plan you have works, that is, the people are the right people to take care of you if the bad thing happens to you, and your assets are going to the people in the way that you want it to go to those people, probably you can take it out, spend 5 minutes, take a look at it, and put it back on the shelf again. You also might want to talk to your CPA or accountant about whether there have been any significant changes that have occurred that it may impact your taxes, because I'm definitely not a tax person. If there's a significant federal or state change, then we, again, try to send a notice out. Again, if you have questions, if you can go ahead and put them in the chat box or the Q&A, rather than me unmuting people, that would be terrific, just because it will help so we don't have background noise and things like that, although I'd love to hear from you. The second question was about the life care planning packet that you can get from the Attorney General's website. So if you go to azag.gov for Arizona Attorney General, they have a life care planning packet, which has a living will for end of life decisions, a mental health power of attorney for inpatient treatment, a healthcare power of attorney for normal healthcare decisions. And they also have some kind of instructions and intent letters in that packet. There's also the pre-hospital medical care directive, which is like a DNR that has to be on orange paper and has to be witnessed by a healthcare professional. If you've done your estate planning already and you have those documents and you have listed in there who you want to be the decision makers, and they're the same people, you don't have to fill out any of those papers, because that would then mean that whatever you did with us or with your attorney, that no longer would be valid, because whatever typically is last in time would control. You also, even if you use those forms, they don't have to be registered at all in order to be effective. If you didn't use those forms, they don't have to be registered with any government agency. They're effective when they're signed, as long as they're signed by you, and then they have appropriate witnesses and notary on the document. So healthcare documents don't require a notary. It can be a witness or a notary, or two witnesses and no notary, or however many witnesses and a notary you want, but no notary is required on a living will, a healthcare power of attorney, or a mental health power of attorney. A financial power of attorney requires that you have both a witness and a notary, and a will requires 2 witnesses. So it doesn't require a notary, but we always make sure that those are notarized so there's no question that the people who signed were really the people who they said that they were. So we don't have any questions about forgeries or things of that nature. So as I said, we also do quite a bit of special needs planning. So I know that there's a question in the chat box, and I will get back to that person in just a minute. But I did get a couple of questions related to some Social Security benefits. So Social Security benefits are a lot of different things. So of course you have Social Security retirement. We have Social Security disability benefits for somebody who worked enough quarters and becomes disabled. We have SSI, which is supplemental security income, which is a benefit for somebody who didn't work enough quarters, doesn't have any assets or income, and becomes disabled. And then we also have something called Disabled Adult Child Benefits, which is a program where somebody who was on SSI prior to age 22, who either the parent retires and starts collecting Social Security, becomes disabled, or passes away, the child who was receiving SSI can convert to that disabled adult child benefit, which sort of gets treated the same as Social Security disability, meaning that there's no longer an income limit for that person, and they would get Medicare benefits 25 months after they qualify for that benefit. So SSI has a whole lot of eligibility criteria, including that the person can't have more than $2,000 in assets and has to have low income. And typically distribution of cash to that beneficiary is treated as income, and that could reduce the amount of SSI that that person would receive. So one of the questions is, a relative hands $20 at Christmas time or at holiday time to an individual on SSI. Is that problematic, and does it have to be reported? So distributions of $20 or less in a month is not income and is disregarded. So normally that wouldn't be reported, and it doesn't have any impact on eligibility. And while I'm sure that sometimes beneficiaries get more than $20 in a month and don't report it, it should be reported if it's more than that, because that would have an impact on the eligibility of that person in terms of how much SSI they would get. So any amount in cash over $20 is a dollar for dollar offset to the amount the person is getting in SSI. So the maximum SSI in 2022 is $841. So if you gave somebody $40 in cash, the first $20 is disregarded. The other $20 would reduce the $841 to $821 in that month. Hope that's helpful. The person put the money in what's called an ABLE account, which is an account that can be established for folks who were disabled prior to age 26 with some additional eligibility issues as to how much can be in those accounts. And so this person took the $20 and put it into the ABLE account, and that's totally fine. Remember, though, the distribution was to the beneficiary, and so had it been more than $20, it still would have reduced SSI, even if then immediately placed in the ABLE account, because it was a distribution to the beneficiary. If it had been given to mom and dad and they said, we're going to give you some extra money, and then the parents put the money in the ABLE account, then it shouldn't have any eligibility issues or reporting requirements. So if you're the representative payee for somebody who is on SSI benefits, Social Security says that you are to use that money first for food and shelter expenses, and thereafter discretionary expenses. And while this person who sent me the email said that the web page says that you're not supposed to be able to tell the person how to spend their money, if you are the rep payee, it is most likely because that person cannot manage money by themselves. And if you think the way the money is being requested to be used is not appropriate for that beneficiary, you absolutely have a right to say, let's use it for this instead, or let's put it in the ABLE account and save it up for later. So if your beneficiary would like to get, I'm trying to think of something, They have a problem with alcohol and they want you to use the money to purchase alcohol. That is probably not an appropriate discretionary use of the money. So your job is to look out for that person. And if you happen to be guardian of them, on top of that, you also have that fiduciary responsibility. And then another question is, if you wanted to take a vacation and you have an adult child who is on SSI, how do you sort of split up the hotel and things like that? So my recollection of the rules is that while you're on vacation, as odd as it may sound, going to a hotel or eating out is not in-kind support and maintenance, so it doesn't count as a food and shelter expense to reduce how much money that person would receive. So if you're going on vacation, the rules also say if your person could not travel without a companion, that you can use their money to pay not only for them, but also for the companion's expenses for that vacation, whether that's travel or hotel or other expenses. So you have some leeway with vacation expenses that you don't really have on your everyday life with your beneficiary. So let's see, I have some questions in the chat box. Thank you so much. The question and answer, which is great. So it says, can someone have an income only trust without having a beneficiary? And if so, what happens to the leftover money once the state's paid off? Would it go to the trustee? So let's go backwards first. As I said, we do some consultations related to All-Tex benefits. All-Tex is the Arizona long-term care system, which is Arizona's form of Medicaid for somebody who requires assistance at home or needs to go to a group home or assisted living or a nursing home or some other long-term care setting. And that program, just like SSI, has some eligibility criteria both for medical, for income, and for how much money they have in the bank or other resources. And so this attendee is talking about an income-only trust. Sometimes that's also referred to as a Miller trust. It is a trust that is required and not a choice when you are applying for All-Tex and the applicant's income exceeds the income limit in that year, which in 2022, I think is $2,523 or something like that. And so that's gross income. So that's before deductions for taxes and before deductions for medical insurance, including Medicare. We have some different rules for married couples, but they also might need an income only trust for the applicant of that married couple if their combined income, if the applicant's income is too high and their combined income is too high. So when we have somebody on All-Tex whose income exceeds the income limit, then as I said, we need one of those income only trusts or Miller trusts. So the question about having an income only trust without a beneficiary, that would be a not perfect trust. So anytime we draft a trust, whether it's a income only trust, a revocable trust, a life insurance trust, a special needs trust, it should always have a beneficiary past the primary beneficiary, right? So if I have a special needs trust set up for my niece, Marissa, and that trust should say, hey, if Marissa's deceased, then this is what happens to her assets that are in that trust. And the same is true for an income-only trust. So the state of Arizona is the first beneficiary, but anything left over, we should say who gets it. If there's no beneficiary after the state, while the trustee would get control of it, they would have to probably go to court and get a court order to determine how to make distributions because the trustee isn't giving that individual, that trustee, instructions as to what to do with the funds that are left over after the death of the primary beneficiary and after the state of Arizona has received its assets. So that's what I think would happen if we don't have a named beneficiary. So next question says, our petition for temporary guardianship of our daughter was declined due to no medical report. Your next hearing is in February. She would rather have her father. Can she sign voluntarily for her father? Do we have to refile in his name? Would a medical power of attorney be a better option? So again, to start backwards, a guardianship is a court proceeding when we have somebody who is incapacitated and thusly not able to sign a medical power of attorney. And you must file a physician's report, a health professional's report, because that is the medical evidence to the court that this person is in fact incapacitated and unable to make their own health, housing, and education decisions. If they're able to make their own decisions, then they don't need a guardian. And if they are not incapacitated, then they could do a medical power of attorney with mental health powers, or a healthcare power of attorney and a separate mental health power of attorney. Before I answer the rest of those procedural questions, the other issue to remember is just because somebody has a medical power of attorney does not give anybody else the right to make medical decisions for that person until and unless they're deemed to be incapacitated. So I have a healthcare power of attorney. I have my husband named to be my agent. That doesn't mean that if I go to the doctor, he must be in the room with me. It doesn't mean that he gets to decide which treatment I get or whether or not I take certain medication. And I don't even have to tell him I went to the doctor. If you are the guardian for somebody, it's as if the person is still a minor child, whether they are 21, 18, or 100. So you would have absolute right to get medical records, and you would be the decision maker over those medical and housing decisions. The other thing about a guardianship is that it can only be terminated, can only be granted by a court, and then it can only be terminated by a court. So if your person gets mad at you and they say, you're not my agent anymore, they can do a new healthcare power of attorney, and it's valid, assuming, again, they're competent and it's signed appropriately. They can get mad at you when you're the guardian, but you are still the guardian until the court terminates your guardianship powers. So in this instance, the hearing was extended or continued so that there could be some medical evidence. If in fact this person is incapacitated, then doing the power of attorney is probably not appropriate, or the filing of the guardianship wasn't appropriate if they have capacity. And if there is going to be a different person to be the guardian, so you as mom filed to be the guardian and the person would prefer to have dad, then an amended petition needs to be filed to show that we have a change in who the guardian is going to be. The new person who's being nominated to be guardian has to complete a new affidavit, about whatever issues they might have. That's a court form. And the new nominated guardian would have to talk to the court investigator when the court investigator calls, and have to be at the hearing, and then make sure they have, proposed orders to get that person appointed and proposed letters. So you would need to submit all new information, even if you have the same hearing date, because it's still over Susie Smith. But an amended petition would need to be filed, and you have to give notice, including personal service, on the parent and the child and any adult children of the child or the person you're trying to become guardian over at least 14 days prior to the hearing. I hope that's helpful. So another question is that you are a winter visitor. Welcome, although today's not really very nice. It's a little chilly and wet out there. Do you need a lawyer in Arizona or in your home state? And what about the location of the executor? So attorneys in Arizona can only draft documents for residents of Arizona. So if you reside in Wisconsin, and I typically look at where do you file your taxes as your primary residence, then you would want to make sure you have documents done there. Arizona has some funky stuff in our state statutes. So you might want to have, for example, I don't know of another state that has a mental health power of attorney in case you needed inpatient psychiatric treatment. So you may want to do a mental health power of attorney, for example, in the event that you need that treatment when you're in Arizona, so we can make sure you can get it without somebody having to go to court and be appointed as your guardian. Your executor, which we call personal representative in Arizona, the one who would settle your probate estate, can be in any jurisdiction, any state in the US without a problem. So if you live in Minnesota and that's where your personal representative lives, and you die here and had property here and a probate's going to open here, that person from Minnesota can absolutely still be your executor or personal representative or agent under a power of attorney, or your trustee under a trust. So it's just a question of, can an Arizona attorney help you? And the answer would be, while you're here, they can. but your primary place of residence is where I would say your underlying document for sure, like your trust would want to be drafted. And I would also tell you all that if you move between states, that doesn't necessarily mean you have to scrap everything you did before. You might just want an amendment that says, hey, it's now under the governing law of Arizona instead of Minnesota. If everything else seems generally okay, that you might be able to get away with that. Your estate planning is good in all the states as long as it was valid in the state in which you signed the documents. Let's see. Are there any drawbacks to having a transfer on death deed for a home that still has a mortgage to be paid off? So Arizona and many other states have something called beneficiary deeds. And so that is a deed that gets recorded with the county while you're alive. So that relates to real estate. Its purpose is to avoid probate when you pass away, but it does not avoid the debts. So it's perfectly fine to have a beneficiary deed, even if there's a loan on the property. The property would pass on your death to the person or persons named in that beneficiary deed. They then could sell it and pay off the debt, or continue to pay on the debt, and they would own the house just like you do. It's just that they still have debt against it. So it's fine to do a beneficiary deed that way. If you have a reverse mortgage, you could still probably do a beneficiary deed. Again, it's still subject to that reverse mortgage. And unlike traditional loans, my understanding of the rules for reverse mortgages, although I'm not a mortgage specialist, is that the property needs to be sold or put on the market if you are no longer in it for a year. And it can only be owned by somebody who is, I think it's 55 years or older, to keep that reverse mortgage, unlike a traditional loan. So there might be some complications with a reverse mortgage, and hopefully I got that age correct. Let's see. I have a trust in another state and I want to change or add distributions. How's the best way to do that with the least cost? So it's funny because we got a call this morning from a longstanding client who wanted to change the beneficiaries of his trust and asked basically the same question. So there's nothing magical about amending your trust. You don't have to see an attorney in order to make it valid. You don't ever want to write on your estate planning document originals, ever under any circumstances. There are lots of different legal meanings that come from that. You can, on a separate sheet of paper, type it up on the computer or whatever and print it out, say, this is an amendment to the Kile Family Trust dated December 28th, 2022. Section 602 with regard to distributions is replaced with the following. And then you would say, have whoever your new beneficiaries are, and then just follow the same execution requirements that happened on the original document. So if there's a witness, have a witness. If there's a notary, have a notary. If there's a witness and a notary, have both of them. And always make sure it's dated, because if we find other documents and they're not dated, we don't know which one was first in time and which one was last in time. I was updating somebody's estate plan the other day, and there are 3 amendments and they're not called first, second, and third. And oddly, they're all dated the same day. And so I have no idea what the intent was as to which one of those would control. So we did a new amendment and said all of these other ones are void, and this is the one that matters with our new information. So just be clear. Remember, you're not going to be around. So having a blank piece of paper that just says section 602 is revoked, I don't know what document you're talking about. Is it being replaced or not replaced? And again, just make sure you sign it, it's dated, and you follow whether it was witnessed or notarized. So hopefully that's helpful to that person. Does income from a Medicare disabled adult child benefit count as income against Social Security disability and all tax? So I'm going to have to parse that out because I'm not sure I totally understand the question. So we don't have a Medicare disabled adult child. So a person who was on SSI prior to age 22 and has a parent who retires, becomes disabled, or passes away is going to be eligible probably for that disabled adult child benefit. If the person is getting Social Security disability income and was on SSI, and then the bad thing happened to the parent or the parent retired, which is a great thing, hopefully, then that is not earned income. So it shouldn't count against the disability benefit. But my guess is it will be the SSI amount must have been pretty small to get the SSD and the SSI. And I am not aware that SSDI, Social Security Disability Benefits, converts to DAC. I think it goes kind of the other direction, but I could be wrong about that. With regard to the all-tax income limit, the DAC benefit does not count as long as the person was receiving SSI, which they would have been when they converted benefits. So there's a specific exemption in the rules that talks about if you were getting SSI and then converted, that does not make you over income for all tax benefits. And I do not know yet what the 2023 income limits are. I'd have to look them up. I'm assuming they're out, but I don't know the answer to that question yet. If a person has no job and no assets except a small home, I understand a bankruptcy would not take their home. What happens if that home is sold and the equity is converted to cash? Now would that person not want to declare bankruptcy because there's no protection for the money? I cannot answer that question. I don't do any bankruptcy work at all. So I just don't know the answer to that question. You'd have to talk to a bankruptcy attorney in order to find out the answer. I'm going to guess that if you filed bankruptcy, I think that there is a time period of what did you do with your assets within a certain time period before the bankruptcy, and what happened to your assets for a certain period after the bankruptcy, where they can get pulled back in or get attributed as part of the bankruptcy proceedings. So probably that would be an issue, but I don't want to opine about that because I don't know. Thank you for all these questions. So the next thing is, can we do a joint guardianship? Absolutely. You can do a joint guardianship. We do a lot of guardianships for kids who are turning 18 who have developmental disabilities, autism or Down syndrome or some other condition, as well as guardianships for people who suffer traumatic brain injuries or have all kinds of other issues that make it so they can no longer manage their own health and housing decisions and did not do estate planning, or it was not, it's not sufficient anymore. So we do a lot of guardianships where we have both mom and dad as the guardians over the person, or siblings over a parent or over another sibling as guardian. We also have sometimes where we have a parent and another sibling over the sibling who needs the guardianship. Usually having not more than 3 guardians. And remember, all of the guardians have the same rights and responsibilities. We don't have backup guardians through the court system. So if you're on the orders, you are the guardian and have all of the reporting and fiduciary responsibilities as any other guardian. And you can set up the guardianship so that each individual guardian can act alone. So mom and dad don't have to take the person to the doctor together to make joint decisions about everything. Or you can say they do have to make all decisions together and unanimously. That is typically a bit problematic from a real life standpoint. And we would hope that the guardians get along with each other so that that's not a problem in terms of them communicating about what they did when the other guardian wasn't present. So hopefully that works out. The other thing, as I said, is guardianships only end with a court order. Obviously, people pass away who were guardians over somebody. We still have to file a notice with the court to say, hey, this person is now deceased. And sometimes we want to put on a new guardian, and they have to go through all the same process you did. Fill out the affidavit, set it for a hearing, talk to the court investigator, all of those same things. But you can do a nomination of guardian, successor guardian in your will or as a separate document. And so that the goal of that is that if I have a separate document, that if the bad thing happened to me, the person listed as the successor would submit it to the court with some other papers, get appointed right away, and then go back and do the hearing and notice and court appointed counsel and all of the other safeguards we have through the statutes. But then we don't have a person without a guardian for any length of time. All right, so I'm still in Arizona since the pandemic started. I am a snowbird, but living here because of health issues. Do I have to get a new trust because I'm living here? What's the criteria that says yes, you're a resident of the state, doing taxes, address, driver's license? The post office has just forced me to change my primary residence to Arizona, even though my primary home is still in another state. So if you want to think about tax issues. So if you're a resident of Arizona, for example, we don't have a separate estate tax. We just look at what the feds are, which is about $12.5 million per person right now. You may live in a state that has an estate tax. You may own property in a state that has estate taxes that are lower than that. And your estate may still have to pay those regardless of where your residency is. If you are here and you're planning to stay for a while and you get a driver's license in Arizona, I would certainly say you're a resident of Arizona. And you, again, shouldn't need a whole new trust just because you changed states, unless there's a lot of very specific language related to that state's statutes, in which case sometimes it's just easier to do a restatement. Also, if you're doing a lot of changes, like you're changing who the trustees are, who the successors are, who the beneficiaries are, what they're going to get, I would prefer to do a restatement rather than try to shoehorn in an amendment and maybe miss some things that could have been changed while we were redoing it. But none of it is required. And I have no idea how a post office forces you to change your primary residence to Arizona. People have lots of different houses and can get mail at all the different houses. So I don't run the post office, so I don't know what that's about. I heard you say that where you file your taxes is evidence of residency. So when you file income taxes, you traditionally, again, I'm not a CPA and I'm trying not to give you any tax advice, but traditionally you would file as your primary residence income taxes, and then you would have your separate filing to show that you had income in another state, but it's not your primary residence. So I know lots of people who go between two states. I have no idea what the rules are, but they try to stay at least 6 months and a day in one of the states so they can show a substantial connection to that state. If that's related to income tax issues and all the income is being generated in that state. So kind of outside my realm, but I certainly wouldn't want somebody who's just, driving down the I-17 and stops in and says, well, I live in Minnesota and I'm going to vacation in California. Can you do my estate plan? That's not enough of a connection to Arizona, I don't think, for an Arizona attorney to be drafting documents. But again, I don't want to give ethics advice either. That's just how I would feel about it if that person came to see me. So I think I have answered the questions that are in the Q&A so far. So I'm just going to talk for a little bit more about other issues that I've seen come up fairly recently. Another question. It said, my husband, at first I thought is a comedian, and I wondered where the question was going, but no, my husband's a Canadian and now a US resident. They don't need trust in Canada, but he has a will. Most of the assets and money is in Canada. Is his will okay there, or must he do something here? He hasn't been to Canada even for a visit because of health issues in some time. So if the assets are in Canada, your Canadian will should be just fine. I would recommend that the husband do powers of attorney here in Arizona. So if he needs some help, that our hospitals, doctors, and financial institutions may recognize that there's a decision maker. So maybe a healthcare power of attorney with mental health powers, or a separate mental health power of attorney and living will for end of life choices might be something that you might want to have, even if all of your assets are elsewhere. So people often ask me, how do I avoid probate? First of all, it is definitely not the worst thing in the world in Arizona to have to do probate. But so if we think about probate for a decedent's estate, because we have a probate division in the court that does guardianships and conservatorships and trust contests and all kinds of other things. But from a decedent's estate perspective, then It's about money or assets that are only in that deceased person's name. So if an asset is in a trust, you don't have to file a probate because trusts don't die. I suppose you could have a trust that has a term limit on it, but I would prefer not to. Anyway, as long as the trust is still valid, if the asset was titled in the trust should say where that stuff goes when the person dies and who it is that's the successor to take over control of that asset. So that wouldn't require a probate. If you have a joint owner for anything other than real estate, you wouldn't need a probate. Last man named on the account gets the money. For real estate, you have to make sure it says with rights of survivorship. So whether it's community property with rights of survivorship or joint tenancy with rights of survivorship, if it just says joint tenants, you probably are going to end up having to do a probate over the deceased person's interest in the property because it doesn't include the magic with rights of survivorship language. And then assets, the other assets that don't require a probate are assets that have a beneficiary named. So if you have an IRA, hopefully you did a beneficiary form and you said what percentages each person or charity was going to get, or it all goes to my spouse. And if my spouse is deceased, who it is that's supposed to get that asset. And so those assets don't require probate either because we have a named beneficiary. You've basically signed a contract with that institution. And so then the person who's listed can get the money. It's really important, however, that you keep track of that and that it is accessible when you pass away, because the institution is only going to talk to the person who is named as the beneficiary. So if I'm not the beneficiary and I send in the death certificate to say so-and-so is deceased, can I collect my money? They probably won't even respond to me other than thank you for letting us know they're dead. But they won't tell you who the beneficiaries are. One of the tragedies of estate planning is that somebody does it and then nobody who are the decision makers know they're the decision makers, or they don't know who the beneficiaries are, and they cannot find the estate planning documents and don't know they exist. So I got a call earlier this week that a person was contacted by their relative at the hospital who said, I'm in the hospital. And so they went to visit them. By the time they got there, the person could no longer communicate. So they went to the person's home and can't find any estate planning documents. And the relative is no longer able to communicate in any meaningful manner to provide any information. And so that would make it super hard for anybody to find the documents. And if you put them in a safety deposit box, nobody knows about it. There's no central registry for safe deposit boxes. Nobody knows where the key is. Nobody knows which branch at the financial institution that money might be in or that box might be held at. And nobody knows where your money or your assets are. So if you can make a list and keep it somewhere that somebody could find it, or hopefully you trust the people you've listed to be your decision makers, your agents and trustees. So tell them, this is where the list is. This is where my book is with all my documents in it. The bad thing happens to me. This is where you find everything. Because if you don't trust them now, when you can defend yourself, that's not a good plan. Just say that. So it looks like, Judy, you've got your hand up, but if you could type into the chat or the Q&A if you had a question, that would be fabulous. And then I'm happy to read your comment or your question. So again, with your estate planning, don't make them a secret. Have a family meeting, sit down, tell people what to expect and tell them where the documents are. Then people sometimes want to leave $1 to the relative they hate the most. Also, one of my least favorite things, because once you make them a beneficiary, they have beneficiary rights. So they're entitled to notice and they're entitled to potentially to inventories and other information. They might not be entitled to an accounting as a specific bequest, but they might hold up the administration by refusing to sign consents or agreeing to things. So if you don't like them, if they're not your kid or your spouse, you don't have to say anything about them. And if they are, you have to specifically say you're disinheriting them and you don't want them to get anything, because leaving them $1 doesn't make them any happier than being disinherited. doesn't make their claim go away that you were under undue influence, or you were incapacitated in some manner, or you didn't know what you were doing. But you don't want to just not mention children or spouses, because they may have a right to receive assets because it appeared that you forgot about them. So again, not stepkids, but children who are yours and spouses who you're still married to need to be named in documents and say what it is that you want to have happen to those people. One other thing on guardianships and conservatorship. So they're two separate things. Guardians are over people, that's over making health and housing decisions. And conservatorship is over money. So those are both court proceedings when somebody doesn't have estate planning, or the estate planning isn't working and they've become incapacitated. So sometimes we see estate planning where we only have a spouse as the named alternate, and the spouse is also incapacitated or deceased. And so now we have documents, but we don't have any decision makers, so we have to go to court. If you are filing for guardianship, don't just file for conservatorship because what the heck, you might need it. You only file for conservatorship if it's something you're actually going to need, like you need access to money, and because you're going to have to do accountings and potentially get a bond and lots of other steps. So it's not just a throw in if you don't need it. For lots of folks who have developmentally disabled children, and they file for guardianship, which can be done anytime after age 17 years and 6 months, they think they need conservatorship. But if you have a special needs trust for that beneficiary, the trustee will manage the money. So no conservator there. If they only have Social Security income, you're probably the rep payee, so no conservatorship there. And if they only have a small bank account of less than $2,000, a guardian can probably manage those assets. They're an enable account. You don't need a conservatorship. You might need a conservatorship to get the money to enable account. So maybe grandma left an inheritance for an individual who is receiving government assistance and is disabled. And so you want to move those funds into the able account. You will need court approval in order to take money that otherwise would have gone to the individual and move it to the able account. You don't need a conservatorship to manage an able account. And I recently read that as of December, don't quote me on this, but there's legislation pending, I should say, that if it passes as of December 31 of 2025, so essentially January of 2026, that the ABLE accounts should be able to be established for somebody who became incapacitated prior to age 46, not just 26, which would be great because we have lots of folks who sadly have accidents and they are over the age of 26 and we can't do an ABLE account for them. We have to do something typically more expensive and complicated. So that's how that is. Let's see. How do you get around only paying $25 an hour for individuals managing the estate affairs? How does a trustee get paid? So sometimes estate planning documents tell us what the rate is to pay the agent or the trustee or the personal representative. Sometimes it just says a reasonable rate, and then we figure it out at the time. If you want your person to be paid a certain amount, you can say it in the documents, but as we all know, $25 today is not going to be $25 tomorrow or in 10 years or whenever the bad thing happens to you. So I prefer to just say it's a reasonable rate. Courts, if we had to file with a court, have a tendency to approve, up to $75 an hour if it's a professional and they're doing something in their profession. Oftentimes they can be paid at their professional rate. So, and it also, I think, depends on the complexity of the issues the person is facing and the amount of money it is that they're managing. So if you're the person and your document said, your mom said you're only going to get $25 an hour and you don't think that's reasonable, you can do an agreement with the other beneficiaries at a rate that feels more comfortable. Or of course, there's always the folks in the black robe at the courthouse that we can go to and say, this no longer makes any sense. And if we had to hire somebody, it would cost this. So we're asking for less than that, but more than what's in the documents. So there's probably some way to resolve that issue if it's after the fact and we don't have somebody to make changes anymore. Trustees pay themselves. Notice has to be provided 30 days prior to a change in compensation to all the beneficiaries. So they need to know that their assets are being spent on attorney's fees. That's, of course, only if the grantor, the person who created the trust, is now incapacitated or deceased. You don't have to, well, of course, you wouldn't pay yourself if it's your own trust. You're just moving your money around. Is a beneficiary and a bound account better than payment on death? Those are the same thing. So brokerage accounts usually call it transfer on death. Retail bank accounts like money market savings accounts, checking accounts usually call it payable on death. And then, as I said before, we have beneficiary deeds for real property. All of that is the same thing. It all means when I die, the person or persons listed on there are going to get the funds. And it's important. At the beginning, somebody asked how often you should look at your stuff. It's important not only to review your estate planning documents, but how you have those, how you have the beneficiary set up to make sure that we're not only looking at, you're not only looking at things that are in your documents, but you're also checking those beneficiary designations so we don't have deceased people listed on your beneficiaries or people you don't like anymore. So often we end up having to do a probate because one spouse dies and the other spouse did not list that who a successor beneficiary was going to be. And so now we don't have any beneficiaries and a probate needs to be opened for that asset. Income earned in another state, is it affected by the address on the statements? So again, I'm not a tax professional. My understanding is it's where the money was earned. So if you're working at a job in Wisconsin, that's income in Wisconsin, regardless of the fact that it gets deposited into your bank account in Arizona. I would guess, although I don't know, if you have a bank account in Wisconsin that's got interest and dividends coming from it, even though the money gets deposited in your Arizona account, that the money is being generated by an out-of-state asset. But you should definitely talk to your accountant or CPA about that. We have lots of clients who have gas and mineral rights in other states. And so my understanding is that the income is generated where that is located, where those mineral rights or gas leases are generating the money, and then they file an income tax return in that state to show that they earned income in that state. But again, I'm not the tax professional. Don't rely on me for tax advice. I'm the estate planning, special needs planning attorney. Well, we're almost at the end of our hour set aside for this purpose. I'm so thrilled that you all could join me today and that we have the opportunity to chat. Remember to make sure you get an attorney to answer your actual specific question. And I was just trying to provide general direction on answers to questions. It's been my pleasure to work with you, hopefully meet you, know you. I appreciate you participating on our webinars. I wish everybody the best in 2023. Stay healthy, and we hope to see you soon. Thank you so much. Take care.